Hey, today we're going to be talking about binding financial agreements law reform. This is a really important law reform to have an understanding about, particularly because questions about property haven't come up in the family law essays yet, and this one definitely does target aspects of property when couples enter into a relationship breakdown. So let's start off with the name of the law reform that we're going to be looking at, which is the Family Law Amendment Act 2000, Commonwealth. This is a law that amended the Family Law Act 1975, Commonwealth. And when you're talking in your outline about what it did, you can talk about the fact that it introduced the ability for binding financial agreements, or BFAs, to be entered into by parties, either before, during, or even after a marriage has begun to break down. These BFAs can be varied by parties, and there can be an application to the court, to the family court, to have them set aside. And they don't just have to apply to married couples, they can apply to de facto relationships, including same-sex relationships as well. So these were brought in 2000 in an attempt to give some clarity in terms of the rights of each party if their relationship was to break down. What are the strengths of this law reform? They must be complied with, so that's a clear strength. And when you comply with the BFA, you're helping to resolve conflict and achieve cooperation. There is clarity to the process of dealing with property after a divorce or a separation, and they apply equally to married, same-sex and de facto couples, helping to achieve justice for all types of relationships. And the other main strength of this law reform is that it requires that both parties obtained independent legal advice about the effect of the BFA before they sign it. And so this helps to achieve just results because both parties know what they are agreeing to and what they are signing. So all of these different types of strengths can be mentioned in a strengths paragraph. And there is an article reference that you can use, which is Working Out a Prenuptial Agreement Proves a Capital Idea, the Australian 2016. That sets out a bit of a summary of the strengths that we've just talked about. However, even though the purpose of bringing in these BFAs in 2000 was to achieve clarity through the compliance focus of them, in reality, the history of BFAs has been very complex and confusing and has involved numerous court cases. So when you move into the limitations of this reform, you're going to talk about that despite its attempt to reflect the values of society and achieve just outcomes, in practice it hasn't always been this way because of the complexity of this area of the law. So we'll start off with the limitations by saying that while BFAs were introduced to add clarity to the process of resolving property disputes, achieving conflict reduction and encouraging cooperation, the amendment has in practice given rise to uncertainty and many legal challenges. So for example, there was a case in 2008 called Black v. Black, so Black v. Black 2008, where the court ruled that the BFA in that matter was invalid because it didn't strictly comply with every requirement of the legislation. And what this did at the time is it caused great panic in the legal community because it threatened the validity of thousands of BFAs, which weren't technically perfect, but had been presumed to be legally valid, that existed between the year 2000 and 2009. So it threw the certainty of BFAs into chaos. The result was that in 2009, Parliament had to respond by bringing in some legislation to deal with this issue. That law was called the Federal Justice System Amendment Efficiency Measures Act 2009. I don't think you need to memorize the name of that law specifically. You could just say that a reform was brought in 2009, and the effect of that law was to enable BFAs to be considered valid and binding, even if they didn't strictly comply with the requirements of the legislation. And that was Parliament's response to make sure that things were okay for the laws, the BFAs, between 2000 and 2009. While this does show that legislation can be used to respond to problems because this law applied retrospectively, it also shows how complex and uncertain the nature of this area of the law is. So it shows that despite the attempt to achieve clarity for people in 2000, even as of 2009, confusion and complexity still remained. So that's how you can argue that limitation. And the confusing and complicated nature of the law was shown again in a case in 2013. case is called Wallace and Stelzer. In 2011, Wallace attempted to argue that the 2009 amendment was actually unconstitutional because it was retrospective. So what he was trying to do is to say, have the court say that this law was unconstitutional. And the reason why he was trying to say that was because he didn't want his BFA to be valid. His BFA would have given his ex-partner $3.25 million. So he wanted that 2009 law removed. And this is discussed in two news articles. Pole dancer case threatens prenups, Sydney Morning Herald 2013, and husband in bid to stop $3.2 million prenup, Sydney Morning Herald 2014. In 2011, the court did decide that the 2009 law was constitutionally valid and that Wallace's BFA was enforceable. And in 2013, the family court dismissed his appeal. So that's why it's a 2013 case. Ultimately, even though the case wasn't successful, it still highlights the complexity and uncertainty of this area of the law, which continues to be an issue for the family court. And finally, the most recent decision in 2017 has been argued to signal the death knell of BFAs in Australia. So a recent landmark decision of the High Court has cast further doubt on the scope and operation of BFAs in Australia. There's a news article that you can refer to. High Court tears up prenuptial agreement between property developer and online bride, Sydney Morning Herald 2017. And this talks about the case of Thorne and Kennedy 2017. This was a case where a 36-year-old Eastern European woman successfully fought to overturn a BFA that she had signed. She signed this on the eve of her marriage to a 67-year-old millionaire property developer. This is, of course, he had threatened to call off the wedding if she didn't sign the BFA. And even though she had received legal advice that it was not appropriate to sign this BFA, and it was actually the worst drafted document that the solicitor had ever seen, the High Court still found that her consent was obtained through undue influence and unconscionable conduct on behalf of Kennedy. So this case is good in some ways. It shows a clear attempt of the courts to achieve justice for vulnerable people and reflect the values of the community, so that if a BFA was based on some kind of unconscionable conduct, it doesn't have to be complied with. So that's a clear strength. But what we're really saying is that this case has created significant uncertainty about how BFAs actually operate in Australia, because what we're trying to do here is put contract law into family law, and contract law and family law often contradict each other. So while contract law assumes parties have equal bargaining power, they clearly don't always have this in relation to the formation of BFAs. So this might mean that most BFAs have been entered into through an imbalance of bargaining power, and perhaps they could all be invalid. This is discussed in the recent article, Landmark High Court Ruling Spells Death Knell for Prenuptial Agreements in Australia, news.com.au 2018, and it was noted here that the inequality in a relationship means that it's almost impossible to have equal bargaining power due to the differences in age, state of health, and mental capacity. So although it's good that this court in this decision refused to have a BFA considered valid because it was based on unconscionable conduct, it again shows the complexity and uncertainty in this area of the law. And it's hard to imagine how there would ever be a time when there was not unequal bargaining power between two parties entering into prenuptial agreements. So those are the strengths and limitations of this amendment, the original amendment, the Family Law Amendment Act 2000. Overall, then you can say that it's partially effective, and you can include this in many places from the syllabus. Obviously, divorce, the consequences of separation in terms of property, the role of courts in the media, any question about conflict, cooperation, compliance, non-compliance, changing values, just outcomes, or legal responses.
Press stop.